City has rested its case. Now, Mr. Coughlin.
Yes, sir.
Call witnesses or testify?
Can I call Officer Weaver, please?
Officer Weaver. Sergeant Dyke, you wait in the hallway, please. So Weaver, you're still on the road, but you're now a defense witness. Whenever you're ready.
Yes, sir. Hello, Officer Weaver. What did you sit down on City Attorney Ormaas's desk when you first walked in?
Objection relevant, Your Honor.
What was it?
Copy the report for this evening.
Get your answer.
Who gave you that?
I printed it out at the police station.
So City Attorney Ormaas did not give it to you today or at any time?
No.
Why did you set it on her table?
Objection, Your Honor. This line of questioning is irrelevant. He's already answered what it was.
Sustaining the objection. Mr. Coughlin, there's nothing wrong with using notes to refresh your memory. You cannot testify from them. I'm sure you should know that. And I assume that he set them down this way, he would not testify from them. There's nothing wrong with him looking at the notes of the case. It has no relevance.
Yes, sir. I guess I just thought the refreshing recollection occurred when you presented it during the testimony for brief.
But it was not used for that. Mr. Coughlin, it was used prior to testimony. The
For
same
coaching.
way you have notes over there. You're entitled to have whatever those notes are. And you can't testify from them, but you can obviously have your own notes.
So it's permissible to be coaching the witness with the
No, sir. That's not coaching the witness.
Did you testify at a bail hearing to increase the bail on the charge for failure to secure load?
Mr.
Objection,
Coughlin,
relevance.
you're entitled to call witnesses to what occurred on July 3rd. I've already ruled that those other issues are outside the relevance of this charge. You cannot use this trial to try some other issues.
Yes, sir.
You already established that there was a bail hearing that Sergeant Dye appeared at some point for some reason, and I've ruled on that. Do not go there.
Okay.
He is your witness. Officer Weaver is your witness. However, he can only testify as to the events of the date of this occurrence.
Okay, Your Honor, may I present for impeachment purposes or refresh his recollection a video of his attempting to break into the rental at?
No, you cannot. That is beyond this case. I won't say it again. Well, I'm not going to say that because I probably will have to. You need to ask questions. This is now direct exam, not cross-examination, as to what occurred on July 3rd about 10:30 a.m. If you have no questions about that, then there's no questions for Officer Weaver. So that's all I'm going to allow at this point.
Okay, so it's just to maybe save the court from the time it would take me to ask him. Any questions I asked him on cross, would the objections asserted thereto would apply here as well?
I don't remember all the questions you asked.
Well,
I don't have them in front of me.
going to bias and things of that sort, sir, they're no more acceptable here than they were on cross.
If you have specific question as to events that Officer Weaver did or said that shows a bias against you, that you can ask, as long as it was before this event. As far as other charges, other cases, no. In other words, if Officer Weaver has called you on the phone and threatened to kill you and threatened all sorts of things, yeah, that's fine. But short of that, no.
Okay. Officer Weaver, did you ever attempt to access the suspect's rental at...
Sir, do not go there.
I'm sorry, I thought you said prior to this incident you...
nothing about accessing your property has anything to do with this case. If you have questions where Officer Weaver made statements or actions that show clearly that he has some bias or prejudice against you is one thing. But as to what he may have done in response to some other case, I'm not going there. This case is a traffic case, that's where it's going to stay. You have other charges and other forms to deal with the other cases.
All right, sir. I understand. I was just confused because he was in the area to respond to a call at that location.
That is why that is allowed in simply as a preliminary question as to what brought him to that position.
Yes, sir.
Sometimes they are just on general patrol and they see something. Other times they're dispatched to some location. That's the only purpose for that. It has no real relevance other than the fact that there was a reason why the officer was in the location.
Yes, sir. And I don't believe I have anything further, Your Honor.
Yeah, okay, there's no questions. And there's nothing to cross. Officer Weaver, you are excused.
Thank you, sir.
Mr. Kaufman, do you have any other witnesses that you wish to call?
Well, Your Honor, if maybe in the interest of economy, if I could just ask, if I do testify, will I be prevented from testifying to all the matters that you've ruled as irrelevant?
If I've ruled it irrelevant, yes. You cannot testify to something that's irrelevant. You can testify as to what occurred on July 3rd with this traffic violation, but I'm not going to turn this into a civil issue of whether or not there's a 1983 action.
Yes, sir.
Or all this stuff that you already talked about.
Okay, so if I did testify and try to testify to that break-in or anything, that would all be subject to a similar
Yes, sir.
admissibility. Okay, so I'll just not attempt to do that out of respect and deference to this court, sir, in a effort to further judicial economy here, and just say I have nothing further.
So you don't wish to testify as to the facts of the occasion?
Well,
That's okay. That's fine.
let me, if I may stop and think for 1 second, sir. Yes, I would like to testify
Okay.
to a limited extent.
You can testify as to whatever you wish to testify with as long as it involves this incident. All right, so go ahead.
Your Honor, he hasn't been sworn in yet. He has not been sworn
I
in.
know. You need to come forward this morning if you wish to testify.
Okay.
Can you take the witness stamp?
Yes, sir. May I bring my notes with me, Your Honor?
No, sir.
Even
Unless you need to refresh your recollection, and then you can ask to do it.
in my dual role as a self-representing.
That's your choice, sir. It's the same reason why the officer turned in his notes, so he would not have them in front of him. You cannot use them. You have to testify from your own memory. If you can't remember something, then you can refresh your memory.
By
Getting the paperwork and refreshing your memory. But you cannot testify from a document.
Should I take them up and leave them face down?
I'd suggest you just leave them right there. You must remember what happened. But if you don't, if you say that you don't remember, I'll provide you with that information. You can look at it. But I don't like to see anybody take notes up there because it's too easy just to glance down and see something.
Okay, and I'll still think, Your Honor, I think the rule of exclusion is still in effect, so I ask.
That just means he can't testify again. He's done.
Well,
He
won't be called again, though.
He will not be because I just excused him again. He wouldn't have come back except that you called him. Because I excused both witnesses. They didn't have to stay.
Okay, so now they're just.
He's done.
Sport.
He's just sitting here because he wants to. He will not be able to testify in this matter.
He's just sitting here for sport.
For whatever he wishes to do, he's a member of the public. If he wishes to stay here, he can. Sir, if you wish to testify, these are the rules. Do not take your notes, come forward and be sworn. If
I
you
don't wish to test.
It's up to you. All right. All right, sir. And do you have any other evidence besides your testimony that you wish to have?
No, sir.
All right, so no offense is rested. Is there anything further?
No, Your Honor.
Let's proceed to closing argument. Go ahead.
Your Honor, you heard the testimony today of Sergeant Dye, then Officer Dye, and Officer Weaver that on July 3rd, 2012, around 10:41 a.m., they were in the area of Summit Road and McCarran Boulevard. They were in a patrol vehicle in that area when they witnessed a silver Honda Accord traveling in that area. They both testified that they witnessed a storage tub, rubber plastic sort of tub on the back, sitting on the back trunk of that vehicle, that Honda Accord, and that they witnessed it fall off of the back of the trunk into the roadway. They further testified that there was a car, a smaller SUV, behind that silver Honda Accord that had to brake and swerve to avoid that tub, which was in the vehicle. That tub became detached from the silver Honda Accord when it fell into the roadway. It became loose from the vehicle when it fell into the roadway, and it became a hazard to other users of the roadway when it fell into the roadway. Upon contact with the driver of the vehicle, they identified the defendant, Mr. Coughlin, as the driver of that vehicle. This intersection, or this area, Summit Ridge and McCarran Boulevard, is within the city limits of Reno. The court has noted jurisdiction for the record. The defendant is currently charged with NRS 484D.850 subsection 2, which states no person shall operate on any highway any vehicle with any load unless the load and any covering thereon is securely fastened so as to prevent the covering or load from becoming loose, detached, or in any manner a hazard to other users of the highway. They both testified that, well, Officer Weaver testified that he did not see any ropes or tethers or anything securing the load to the vehicle. NRS 484D.850 is incorporated into the Reno Municipal Code by Section 1.04.015, which states the commission of any act within the corporate limits of the city of Reno, or the failure to perform any acts within such corporate limits, which is made a misdemeanor by the laws of the state of Nevada, is declared to be and shall constitute a misdemeanor under this code. It is that section of the Reno Municipal Code which gives this court jurisdiction over the NRS 484D.850 violation that occurred on this date. The officers both testified they had a clear and unobstructed view of the silver Honda Accord and the storage tub on the back falling off into the roadway. Their testimony is consistent. It was clear. It was unequivocal. The city submits that there is sufficient evidence to prove the defendant guilty of this charge beyond a reasonable doubt. I'd ask you to find him guilty.
Yes, sir. And I object to the extent to which City Attorney Ormaas is characterizing the veracity of their testimony in her closing argument and misstating facts not in evidence. Your Honor, the city is pursuing a charge that they did not appropriately amend and or serve upon the defendant here. Further, during the pendency of this matter, both the city attorney and the court appointed defense counsel violated the stay required under 178 of 405. The stay is only respected when it's convenient to the city attorney and or the defense counsel, and when it's not respected. When it comes to Mr. Sotelo being asked to do some work, oh, there's a stay, I can't do anything. When it comes to moving the case along, despite the pendency of the competency order, the case moves right along. Notices are set. The hearing dates are set. Notices are sent. Things proceed. The testimony by these two officers was inconsistent with respect to where Officer Weaver and where Sergeant Dye are alleged to have personally received the tubs fall off. Sergeant Weaver testified as to retaliatory animus towards the suspect and a goal to have him taken off the streets to, quote, protect the public, evincing an impermissible basis for this pullover and the subsequent arrest and 20-day incarceration and unlawful search and seizure of the suspect's vehicle. But chiefly, is the deficiency of the pleading, and that it prejudiced the defendant with respect to not having any notice of the amended complaint, and the extent to which the court-appointed counsel not only failed to follow this court's order in presenting some motion directed to the particular point of law that was put forward on September 4th with respect to the fact that this was a failure to secure a load on a truck charge as originally put, and which has subsequently purportedly been amended, though no such motion to amend or amended complaint was ever received by the defendant. As such, the city should be left with the charge as originally entered, which is inapplicable here in that it applies only to trucks. Thank you, Your Honor.
No, Your Honor, I'll submit it.
The amended complaint is prepared and served by the certificate of service pursuant to RCA 5B by Legal Secretary of the Criminal Division, causing for mailing to Reno, Nevada, first class postage, a true and correct copy to the defendant at the then known address. The fact that he had moved and the post office didn't forward it, it's not a matter for this court. This matter will be taken under advisement with a written order within 10 days. Before you leave today, Mr. Kaufman, I want you to make sure that you confirm your correct address with the marshal, so that when I send out the order, it will go to you correctly. Whatever address you give the marshal this afternoon is where it's going. If you don't get it, your problem. Fortunately, sir.
Yes, sir.
Thank you.
Thank you.
Just let me know any hours or.
Okay. Will do.
It's going to be closed. B-boy, please. Thank you, sir.
Okay, Chief, it's been taken under advisement, so he has no business.
On the failure to appear, be $150 fine, it's a total of $270. And you can pay the fine in case she is with him, it's outside the door, down to your right through. Thank you, sir.
Just go down to the clerk's office. City versus Zachary Coughlin, case 12 CR 12420. Defendant is present, representing himself. Your Honor, there is one charge pending. It is a secured load violation under NRS 484D.850 subsection 2 as adopted by 1.04.015 of the Reno Municipal Code. It's my understanding that the defendant would like a trial this afternoon. The city has 2
We already
witnesses.
began a trial the last time we were here, and the issue was whether this citation applied to a vehicle other than a truck. So I believe it was, as I recall, cited under that point shifting loads which were underneath trucks.
It's my understanding, Your Honor, that there were some pretrial motions
Yes.
and the court ordered briefing. Mr. Sudi subsequently amended the charge. My understanding is that the trial never actually began, but I was not here last time.
Well, there were pre-trial motions. They were oral, and the court asked for points of authority, received none. This was a motion dismissed by the defense. Did you have any material for that, Mr. Kelly?
Your Honor,
You can have a seat.
yes, sir. I don't believe I ever received the motion of defense if Mr. Sotelo indeed filed one in response to your prompting at the September 4th.
It was an oral motion made by him, I believe, and there was an issue about the validity of the citation or of the code, and it was continued for a written motion because the city had not been noticed with that.
Your Honor, if I may make an introductory interjection.
The city has now filed it under NRS 484D 850 parenthesis 2, which is incorporated by reference within the civil code. But it's the same complaint on about July 3rd. The vicinity of Summit Ridge Drive, McCarran Boulevard overpass. They're operating a motor vehicle with plastic storage tub resting on the rear trunk lid, unsecured while driving eastbound. The storage tub fell off the rear of the vehicle, landing in the middle of Summit Ridge, causing a small vehicle to have to swerve around it. That's the complaint, is that correct?
That's my understanding, sir.
You said you had a motion or something?
Yes, sir, Your Honor. Just in case I need to bring this up at the outset, I believe there may be an issue as to whether I was properly noticed on this date here today. So I would just like to preserve that to the extent further. Mr. Sotelo, I believe, moved to get an order allowing his withdrawal from this case during the pendency of a competency evaluation involved at 178.404. 405 made applicable by NRS 5.071. I would like to move for a mistrial here and set forth the bases therein, in addition to a continuance and or a motion conflicting out the city attorney, and with all due respect, sir, in no way applicable to you yourself, but conflict now through Reno Municipal Court.
The first thing we talked about was improper notice today's date. Sent certified mail. We upgraded the address, and it's resent to you. So obviously you have notice you're here today.
Well,
So at this point, you're moving to a mistrial because of lack of notice?
well, Your Honor, with respect to the notice issue, I've had my motion for notice and service issues have been something the city attorney's office has continually affected a overly formulaic approach to with respect to any of their prosecutions of me this year. Further, City Attorney Roberts was able to get my motion for new trial dismissed based upon what I believe is an incorrect assertion by her with respect to notice. City Attorney Ormaas has
Okay.
made.
Let's not go to this other case. I want to keep it with this case. Your first thing that you asked for was something because of improper notice,
Yes, sir.
and you were asking for what?
Well,
You're asking for a mistrial? Is it
or,
improper notice?
or a continuance, or my merely appearing here today does not make the notice effective, and I believe I'm able to reserve an argument as to the lack of sufficient notice of this hearing.
Well, you're here.
Well, that's the
the
court
notice was sent to you,
sanctuary.
and you responded by being here. I don't know what else notice you'd be.
Well, I'm not exactly sure when I became aware of this, sir, but I do know, I believe I came to the filing office last week and inquired as to when some court dates were you mentioned that the certified mailing was resent to me, which I think would tend to indicate that the first one may not have been.
The first was to your post office box that was listed earlier in this case, and it was listed on your DMV record, and it was returned indicating that you had changed your address. So it was resent October 30th, or excuse me, November 19th, and you are here, so.
I think I just got it this weekend on Saturday from the post office, so it prejudiced my trial.
Well, it was sent earlier. In fact, and the notice was sent to you, so motion for dismissal is denied.
I did file a appropriate change of address in a timely manner, so the fact that it was
Apparently not with the Department of Motor Vehicles, because they still show your address as the post office box.
I don't know that the Department of Motor Vehicles is where the inquiry is to whether I updated my address appropriately to make any service deficiency.
I don't see the deficiency. This is. There have been several charges. The last time you were here was September 4th, and that was the one when you were present with Mr. Sotelo. At that point, the only charge was the shifting loads. The other charges were dismissed.
Mr. Sotelo failed to follow your order to file a motion to dismiss. Further, he violated the competency and the state required by a pending order for competency. Further, Judge Nash Holmes testified at my formal disciplinary trial before the state bar on November 14th, and Judge Howard was listed therein as on the designation of witnesses and summary of evidence. Further, Judge Gardner, by way of Judge Nash Holmes' NG 12-0204 or 020434 grievance, filed a grievance against myself on behalf of all other municipal court judges, thereby making that a pending matter before the state bar there.
I don't believe that's quite accurate, because I never signed anything.
Well, she held it out that way, Your Honor.
No agreement has ever been signed by me. I never met you until the last time you were here with Mr. Sotelo.
I understand.
I do know that the subpoena was sent, which was invalid, and it was quashed. Whether any of the judges showed up or not was up to them. But the subpoenas were not properly filed. I mean, after all, you can't sign a subpoena in this particular case.
Those subpoenas were stemming from the state bar hearing, wherein the state bar's representations to me under SCR 105 sub 4 alter NRCP 45's subpoena.
Whatever that is,
reports.
has nothing to do with this case.
Okay, but Judge Nash Holmes
I don't.
March
This
14th.
isn't. I'm not Judge Nash Holmes.
But she held herself out as filing her
That's
grievance
her
on
problem.
behalf of you.
No, she didn't. Well, she may have said whatever she said. However, she had no authority to file a grievance on behalf of me. I have no reason to have a grievance with you. I've only met you once, and that was on September 4th. when you were here the last time,
You did have one other case, Your Honor, that was assigned to you involving me. It was a jaywalking arrest, much like the Judge Nash Holmes case, wherein I was sentenced to a sort of transmogrified summary contempt, criminal nature, or disciplinary hearing type order on February 27th. You had a case that on that date was transferred by Administrative Judge Gardner, whose sister filed a grievance against me as well, that he received from her and passed to Judge Nash Holmes, that it appears was passed to the State Bar by the Reno Municipal Court, in somewhat of a ghost grievancing arrangement. But you did have a case, 12 CR 00696, that was transferred from your court to Judge Nash Holmes' court on that very day, February 27th.
it may be, I don't remember. The only time I remember seeing you having invitations that I saw you in court was September 4th. I did receive a notice from the State Bar of a temporary suspension. That's only because every judge gets that same notice. But other than that...
I don't know if that notice actually lists municipal court judges on it.
You did. I got it.
All right, I'll
It
take
comes
your
to
word, sir.
any attorney action goes to all judges in the state, so that
I'll take your word, sir. I believe Judge Nash Holmes forwarded a police report to the State Bar in April, while that matter was pending, and I don't believe divulging that report was appropriate. Further, Judge Howard has contacted the State Bar in April. I have some case law with respect to the extent to which it's impermissible under the canons of judicial conduct for...
Well, how does Judge Howard and Judge Nash Holmes' behavior affect this case here?
Well, they've been, at least Judge Howard, Judge Gardner has indicated that he has presided over meetings of the municipal court judges that were held to discuss me and the approach in dealing with me. It's been represented to me, at least by inference, that you were in attendance at those meetings.
I may have been at some meetings, but I'm at most of the judges' meetings. But there was nothing discussed about you in this case. This matter is one that was continued. You first appeared, as I said, September 4th. If I had a case in February that was transferred to Judge Nash Holmes, I certainly won't disagree with you because I don't remember back in February. The only thing that was discussed that I can recall is that your status is whether or not you were a different court, I believe, ordered a competency hearing, and that we should continue our cases until that was completed.
Well, that was violated when you granted Mr. Sotelo's order allowing his withdrawal on, I believe it was September 30th, and that competency order didn't come back until after that. And that brings up the point that...
One stop right there. Let's just take this one at a time. Judge Safraza ordered the evaluation on September 7th.
just that violation of those competencies.
Please, let me see what I have here, so I carry, continue one thing over another.
Yes, sir.
An awful lot has been filed. Previous evaluation was done last spring. Actually, with the evaluation out of custody. It was Judge Elliott from District Court over there.
Yes, sir. In the trial setting, in the trespass case involving Judge Gardner, where he refused to recuse himself, which is now detailed in the past Supreme Court case 61901, was done on March 8th.
That finish reading the file, please.
I couldn't
I
understand.
have.
Yes,
My understanding was that the evaluation came back that you were competent, and that is why the case proceeded.
Well,
Let's see if I personally have in my file about the evaluation. It looks like I don't, because I never ordered it. It looks like there's a possession of stolen property and petty larceny in a different case. Which had a hearing set October 22nd.
given that Mr. Sotelo's order granting his withdrawal was September 30th.
Can I make sure I have nothing else here?
Yes, sir.
The matter was discussed, and the only meeting that I recall was that these cases were proceeding. Judge Gardner proceeded with the case with you and went through it with you. There were no difficulties.
When he violated the stay on multiple occasions on the March 8th trial setting, the trial on April 10th, and again on
July
May 8th.
On July 19th,
June 18th, the trial date?
July 19th is notations from Judge Gardner that the evaluation from the Washoe District Court found you competent at that point.
Oh, that's when I was in jail for 20 days on this case. Incident to an improperly noticed bail hearing.
So this is a different case.
That's this case, sir.
This is.
I spent 20 days in jail on this.
Today's your day set for trial. You are here. On September 4th, this court had been informed that the district court had found you competent. The District Court did not forward that to us.
On September 4th, you say, sir?
Yes, that was the day you were here last, appears. September 4th, here with Mr. Sotelo.
And then subsequently, the September 8th court date was suspended in light of the September 5th order for competency evaluation by Judge Barraza, made applicable to this court under NRS 5.071, wherein that, I believe it was September 17th or 18th, the court date in this matter, was pushed out further. And in that time, by September 24th, I believe, Mr. Sotelo, rather than responding to your order to craft a motion speaking to the legal issues that you set forth, he instead moved to withdraw his counsel, and in doing so also disparaged me somewhat in indicating he was withdrawing due to feeling I was committing some reprehensible conduct or some pattern.
No, he did not say that. He filed a motion to be withdrawn based on the statute, and there was nothing in there in the statute that
Repugnant. That he finds repugnant is the language that was in it. Course of conduct he finds repugnant that the client wishes to maintain as a basis for his withdrawal. He didn't specify what exactly.
I don't know. When a defense attorney files a motion to withdraw based on inability to maintain a relationship with client, they do not divulge anything that's happened in the discussion between the attorney and the client. There was a hearing from Judge Fraza in a different court.
That would be the fourth order of withdrawal granted to a municipal court defender this year in a matter wherein I was
This is a motion.
supposed to be defended. I wasn't given a counsel in.
It's hereby ordered defendant be examined by a psychiatrist. This was the Justice Court case, ordered September 7th. The hearing was held on the 15th day of October.
I don't believe that hearing was held.
I don't know. There is a motion filed September 16th by Mr. Sotelo. At that point was your counsel. He learned on that date that you were scheduled for evaluation by Judge Fraza. And there would be a competency evaluation hearing on October 15th. Department 2 of the Reno Justice Court. Mr. Sotelo immediately notified Brian Sudi of the City Attorney's Office. Mr. Sotelo and Brian Sudi are requesting this court to continue the due date of filing the motion and dismiss until after October 15th hearing. That may be dispositive of the case. Parties are requesting the defendant's motion to dismiss be filed October 22nd. This will afford the parties an opportunity to learn the outcome of the competency evaluation. That was the request for continuance.
I was not copied on that.
That is why it's taken 2 months to reschedule this trial. On October 3rd, notice was sent to you at your post office box.
And I probably changed it of address on October 5th, sir.
But we didn't have it on October 3rd.
You said October 3rd?
On November 5th, 2012, received a email reportedly from you apologizing for the confusion. Please ignore the address on April 12th. April 2012. And notifying us of your current contact information and your email address. But this was received by us November 5th.
The change of address.
Motion to be relieved of counsel was filed October 1st. September 3rd, received October 1st. So is it your statement today in court that there was no evaluation and no hearing?
The evaluation, and just to correct my earlier statement, I filed a change of address with the United States Postal Service on October 5th.
Yeah. This is what you sent to us.
Right, but if you mailed me something, I think you said on October 3rd, that would be affected by a change of address with the U.S. Postal Service to that P.O. box that I believe you would have sent that to. There can be a bit of a delay in something about 10 to 14 days, I believe.
What happens to the post office is not my problem.
Okay, but
Our
I've had,
situation is that we send the only address we have. You had not notified us of the change of address until November.
I don't know if that's,
The-
I emailed it you in November, I might have notified the counter previous to that. But I've had an extremely rigid application of procedural rules applied to me by every department of this court I've appeared in this year, whereas the city attorney and the court-appointed defenders have not. My law license has been suspended for 6 months based upon a ruling by Judge Howard, which he admits he in part made based upon his mistaken belief that I caused the first continuance on the November 14th date, when in fact I had not.
Well,
And I was not appointed
let's not go to
court-appointed
Judge
counsel.
Howard, I'm not him. And
Well, but you're part of the same court, and I would like a couple minutes to set forth my basis for believing this court is conflicted out here in this matter.
In order to file a motion to disqualify a judge who is not a justice of the Supreme Court, it must be done in advance. It must be done with a sworn affidavit as to the cause, and it has to be presented ahead of time. It cannot be presented the day of the trial.
Well, in advance of what? A trial that I was properly noticed on and served notice of?
Well, you're here.
Well,
Yes.
that doesn't excuse technical compliance. Clearly, the city
Well,
of Reno has held that
If-
against me
if
5
there-
times this
If
year.
there was anything that you felt that would put me in a position where I have to disqualify myself, that is set forth in the NRS for how to disqualify a judge other than a justice of the Supreme Court. And it has to be done in writing, ahead of time with notice, and it has to be with an affidavit of the specific reasons why you feel this particular court, me, cannot be fair and impartial. I have nothing to base anything about fair and impartialness. I have nothing else other than the fact that I have nothing else to judge whether I know you. The only time I know I saw you was when you were here for the trial date before. You said I saw you in February. Okay, maybe you did. I don't know.
No,
I
I
don't
didn't see
remember.
you, sir. I said you had a matter that was curiously transferred the same day that Judge Nash almost put me in jail for 5 days. It was transferred to her by Judge Gardner, who refused to recuse himself from hearing the criminal trespass matter. And both those matters I just referred to involve Richard Hill. And courthouse sanctuary doctrine was violated, I believe, by the Reno Municipal Court marshals on that same
Sir,
February 27th.
that is not before this court. The only thing that so far is before this court is your request to have me not hear this case. And that has to be filed specifically under NRS. There are specific standards to file a motion to disqualify.
But there's standards to notice me on this trial date too that need to be followed. And you said the court received back that certified mailing, which puts this court on notice.
And then resent it.
And I have to have that notice a certain number of days prior to this trial date. And the return receipt requested on that notice will only show that I got it on Saturday, 2 days ago, which is not sufficient notice.
Well,
so therefore
that is because
you're
they
ruling
went to your address, and when they go to a personal address, they put a card in your mailbox. Why, whether it takes you a week, 2 weeks, 5 weeks, a month, whatever, it's your situation. It was delivered, the notice was sent, and it was in your box. You chose not to pick it up, that's your situation.
The court didn't send it by first-class mail.
Send it certified mail to RMC.
But I believe the requirement might be that it be sent by first-class mail as well. And that's an argument for the city attorney to be making, not the court.
No, you're making the argument with the court, but I have no jurisdiction today. So at this point, there is a trial on a charge of, which has been, the number has been amended, however, the claim is the same.
And the bases for the conflict are new to me. So even
What's new?
well, I'll tell you if I'm given an opportunity.
All right, go ahead.
Okay, and the newness is that I had a November 14th formal disciplinary hearing in the State Bar of Nevada, wherein Judge Nash Holmes appeared and testified telephonically under oath. Further, the State Bar of Nevada violated SCR 105-2C, presenting a good cause or excusable and neglect basis for any lack of timeliness on my part here in setting forth the basis for the recusal or conflict in now either the Marina Municipal Court and or the city attorney's office, which I believe might be a bigger issue, is the city's attorney's office. But Judge Nash Holmes testified under oath as to matters involving Reno marshals and city attorney Ormaas as well, incident to the February 27th traffic citation now stemming from being told to leave Richard Hill's office. These are detailed extensively in Nevada Supreme Court filings in cases 6-1, 901, 60302, 62104, I believe, and 60838. But one, I didn't know the testimony of Judge Nash Holmes until I heard it on the 14th. Two, her testimony substantially departs from my recollection of events, alleging some disassembling of a smartphone in a restroom after she had queried me as to recording devices and or recording. She alleged that the restroom break in that trial occurred after her purported interrogating me sua sponte with regard to recording devices. I submit that I've reviewed the audio of that trial, and there's one restroom break, and there's no mention of querying me on recording devices until after that restroom break. So to the extent that she's remixed the orders of those two events, and then subsequently purported that Marshal Joel Harley indicated to her, again, not in an affidavit, not in compliance with NRS 22.030's affidavit requirement for conduct occurring outside the immediate presence of the court, incident to her purported misdemeanor of criminal contempt finding. Though she cites the NRS 22.010, a civil contempt statute, she characterizes it as misdemeanor criminal contempt without citing to NRS 199.340, Nevada's criminal contempt statute, which nonetheless is plenary and not summary. Beyond that, Judge Nash Holmes attempted to transmogrify a simple traffic citation trial.
I'll let you know. How do you define the word as transmogrified?
I didn't know what it was until I was looking up the case law on this, but I think it means to change the nature of something. Wherein she changed the simple traffic citation trial, I believe, incident to being fed by Bar Counsel the standard necessary under SCR 111 for an ethical violation, not 111, that's conviction of a crime, under SCR 102 for an ethical violation, wherein suddenly in her order on March 12th, the Schaefer standard of by clear and convincing evidence appears, along with essentially a copying and pasting of most of the rules of professional conduct into an order. That seems to be a second bite at the apple vis-a-vis her order of March 28th, wherein I was summarily sentenced to 5 days in jail. That matter was suspended. It's still suspended, incident to her writing a grievance to the State Bar of Nevada on March 14th, 2012, wherein she purports to be writing it on behalf of all the other Reno Municipal Court judges whom she alleges the State Bar of Nevada will have the full cooperation from in pursuing this grievance. Further, Judge Gardner admitted, to get back to how this is newly discovered evidence or only made available to me so recently that it justifies either a continuance or an opportunity to more thoroughly set forth the bases, I believe, for the court to examine its own conscience under a conflict or recusal analysis. Again, with the statement that, Your Honor, I know nothing about you yourself specifically that would augur towards that, other than perhaps Judge Gardner indicating that all the judges sat in on a meeting with respect to me, so I certainly don't mean to disparage this court's impartiality or well-earned and long-standing reputation as the longest tenured municipal court judge. Just a side note, I recently read something that you had written about the first municipal court judge in Reno, and I found that quite interesting, and it was something incident to an issue they were having down in Las Vegas with respect to the fact that the senior judge, it's not a rotating situation like the administrative judge is here in the municipal court, and some of the complaints they have in that regard in Las Vegas. But just to get back on track, Your Honor, I was not provided the materials by Bar Counsel required by SCR 105-2C until approximately 6 days prior to that November 14th hearing, despite the rule requiring I be afforded access to those at least 30 days prior to the hearing. Those materials included a huge box of documents, base stamping into the 3,000 or so pages. In those materials, there's emails from Judge Howard to the State Bar of Nevada. I believe there's emails from Marilyn Tognoni, Judge Nash Holmes' judicial assistant, and/or Municipal Court Administrator Cassandra Jackson, and a number of reports by the City of Reno Marshals. I submit that I have respect for the Reno Municipal Court and its marshals and judges and administrative staff, and I think a lot of this fall, and the City Attorney's Office as well. Excuse me, Your Honor. And I'd submit that a lot of this fallout and from my view, negative interactions has been intended to an unlawful summary eviction from my law office that commenced in August of 2011 involving Richard Hill, who's attached to the traffic citation case wherein I appeared before Judge Nash Holmes. He's attached to what Marshal Hartley was serving me an order show cause hearing in the appeal of the eviction on the 27th. And there's just been a lot of fallout from that. Granted, there's things I could have done better as well. But I think by and large part, the Reno Municipal Court is a court that upholds very high standards of impartiality, fairness, professionalism, and the same can be said of the City of Reno Marshals. But there's just been a confluence of factors here that's kind of touched off a number of unfortunate events. Getting back to your pointing out that there are rules, there is an affidavit, there's an amount of time wherein a conflict needs to be pointed out. Vis-a-vis my argument that there's somewhat of a newfound basis. One, I wasn't entirely clear on what Judge Nash Holmes' testimony would be on November 14th. Her testimony was quite damning. I wasn't able to rebut it, even though I offered copies of both the tape of that hearing that I bought from this court and the one that Mr. King, State Bar of Nevada Counsel, provided to me as leftovers from a formal disciplinary panel taking place on or about April 10th. Judge Howard, Judge Gardner mentioned at a trial date of April 10th that he met with my court-appointed counsel at that time, Keith Loomis, in the morning, and City Attorney Hazlett Stevens, and they discussed some matters, and that he was aware that formal disciplinary hearing panel would be meeting, I believe, that day, and that he received a 3-year-old order for sanctions against me by his sister, family court Judge Linda Gardner, that resulted in my was cited as the sole cause for my being fired from Washington Legal Services, which eventually wound up in a wrongful termination lawsuit now on appeal before the Nevada Supreme Court in 60302. Judge Howard of the Reno Municipal Court indicated that he passed that order on to, I want to say Judge Nash Holmes, but he might have indicated to all the other RMC judges. And it's my understanding that April 10th date was violative of the stay attendant to the February 27th order for competency evaluation by Judge Clifton. And further, in Judge Nash Holmes' March 14th grievance letters to the State Bar of Nevada, she admits and references communications between the municipal court and my Washoe County public defenders at that time. That I believe, one, beyond the extent to which she was alleging I was decompensating, put her on notice of the order for pending competency evaluation that should prevent the February 27th date from going forward, and my 5 days in jail, and this bar grievance, and all this. Just to wind it up, Your Honor, and focus more specifically on any bases that's somewhat new that would justify any finding you're making that I have not sufficiently pled the conflict. I haven't really touched on the city attorney's offices. I have filed grievances against multiple prosecutors for the city attorney's office, and but I was only provided this box of materials by the State Bar of Nevada in violation of SCR 1052C on November 8th. I had the disciplinary hearing on November 14th, and then the matter you alluded to in the Regional Justice Court on November 19th and 20th. So my ability to present a timely motion to this court, to the extent that my arguments that I wish to reserve with respect to my not being sufficiently noticed in technical compliance in the manner to which the Reno City Attorney has always been afforded recognition thereof, including dismissals of my appeals and motions for new trial by City Attorney Hazlett Stevens and City Attorney Roberts, should not be found against me here. And I feel I've gone on. I appreciate the time you let me go on, Your Honor. I would like to reserve the opportunity to set forth some conflicts for the city attorneys, but I've been talking so long at this point, I think I don't want to wear out my welcome, sir.
We'll take a short recess now.
Looked up in RS 1.235 procedure for all-time judges other than Supreme Court justices, which is the issue here today. this court's mind, Mr. Coleman, that you have not followed the procedures because these procedures are very specific. One second, please. Any party, I'll paraphrase it, but the proceedings in any court other than the Supreme Court proceeds to disqualify a judge for actual or implied bias or prejudice must file an affidavit specifying the facts upon which the disqualification is sought. The affidavit of the party represented by an attorney must be accompanied by a certificate that is filed in good faith and not for delay. Except as otherwise provided, the affidavit must be filed not less than 20 days before the date set for trial or hearing, or not less than 3 days before the date set for a hearing or pretrial matter. Except as otherwise provided, and I'll get to this in a minute. If the case is not assigned to a judge before the time required under subsection 1, the affidavit must be filed within 10 days after the party or the party's attorney is notified that the case has been assigned to a judge, and so forth. Regardless of what happens subsequently, you know that I have been assigned to this case since September 4th when you appeared last, which is a couple of months ago. If the case is reassigned to a new judge, there is some leeway, but it has not been reassigned. The case law attached, there is a provision that if the basis for the belief that there is bias or prejudice came later, so that you cannot file within the proper time, there are exceptions for that. But as I recall what you stated, that the basis for disqualifying me is something to do with a bar hearing that was held November 14th or 15th. That's still a couple weeks ago. I have no actual bias or prejudice in your case. Regardless of what Judge Nash Holmes may have indicated, she did not have my authority or any other judge's authority, as far as I know, to represent our position. I was aware that there was a hearing. There's a copy of the subpoena that you issued was provided to me, even though I was not actually named in the subpoena. I played no part in that hearing. There's a very important reason why the motion or the action to disqualify a judge must be in writing and accompanied by affidavit, because it has to be investigated. Because once it is properly filed, this court, or the judge against whom the petition is filed, shall proceed no further with the matter and either transfer the case to another department, if there is more than one, or request another judge from another district to hear the case and file a written answer within 5 judicial days, admitting or denying any or all the allegations. Since you did not file it properly or in writing, I can only respond to what I heard you say earlier this afternoon. But given the fact that there's been no change of judge since we last appeared, you last appeared here, which was on September 4th, which is more than enough time for you to have filed a petition.
There was a
And
pending
even,
competence
wait,
order until
sir.
October
No,
22nd.
no, stop. You've had your chance. Now it's my turn.
Yes, sir.
Since you chose to do this orally rather than in writing, I have to make the record in this case as well. Even if something that occurred at the discipline committee meeting, your discipline hearing in the middle of November, showed to you that I may be prejudiced or biased, you still would have had sufficient time to file it before today's date. It can be filed, it could have been filed ahead of time because it has been more than 2 weeks since that occurred. Based on the fact that this was not properly filed and there's no exception, that this court can find that would provide you an additional time to file something or to do it orally, and a review of the case law, which is pretty extensive. Your petition is denied. And let me see, I'll take a note here. We're at the point now where there is a continuation of a trial, which is probably in proper terms if it didn't actually start, but a continuation of the item set for September 4th, which was a violation of secured load and covers on loads. There has been a change in the numbering system from the City Council. However, the language has not changed. Nevada is a notice pleading state, and the language on the amended complaint does not change what has been actually charged, only the code number under which it was charged. As I said before, the complaint reads that on or about July 3rd, 2012, the City of Reno, State of Nevada, in the vicinity of Summit Ridge Drive and McCarran Boulevard, did operate a motor vehicle with a plastic storage tub resting on the rear trunk lead unsecured while driving eastbound Summit Ridge. The storage tub fell off the rear of the vehicle, landing in the middle of Summit Ridge, causing a small vehicle, SUV vehicle, to brake to swerve around it. That is the charge. It was declared upon information relief. The officer in this complaint, in this case, which is the same charge, originally charged, just under a different citation of it. The matter is set for trial. Mr. Coffin, are there any other pre-trial motions?
Yes, sir. I'd like to move for a continuance, Your Honor, based in part upon the city attorney's failing to provide me the picture she attempted to hand me today in the hallway in a timely manner. failure of my court-appointed defender to wait until the defending competency order was resolved on October 22nd. During the interim defending competency order, he moved to withdraw his counsel. So, to the extent that there's a rigid application of procedural rules to me, I would ask that the same be applied to the conduct of the court-appointed counsel here and to the city attorney in light of their violation of the stay under NRS 178.404 and in light of the
What stay?
propounding stay during the pendency of a competency order, and in light of the city attorney's failure to propound the materials under I believe it's in NRS 174 in a timely manner.
So motion to continue for lack of discovery of the photograph?
Well, and it's for due good cause in that I've had a formal disciplinary hearing on November 14th and a petty larceny trial wherein I was forced to represent myself on November 19th and 20th, and a hearing on November 20th, 7th before Judge Clifton, wherein my public defender was relieved. And in light of what I believe is misconduct attended to my court-appointed counsel in this matter, not making a relevancy objection during the unnoticed July 5th bail hearing increase, which resulted in my spending 20 days in jail and the bond going from a bondable $1,400 to cash only $3,000, where Mr. Loomis didn't object to the relevancy of the testimony by Sergeant Dye at that time. He later on told me it wasn't relevant enough to subpoena the police reports that
At
Sergeant
this
Dye
point, you're
testified.
way off the subject. The only thing that I've heard so far that has any bearing on motion to continue would be lack of discovery. The other issues as to other problems you've had with other hearings and other trials are not good cause for continuance at this point. They may have been, that they are more of a general matter. The only issue for continuance is lack of discovery. Ms. Ormaas, is there a response to that?
Your Honor, my response is twofold. One, I don't know if we ever gave these to Mr. Coughlin. I have nothing showing that we did send them as discovery, so I cannot stand here and say that we did send these in advance of today's trial date. I did make copies and attempt to hand them to him in the hallway today. He refused to take them. I'm not intending on using them during the city's case in chief. I don't think they're necessary to prove the case beyond a reasonable doubt, so I don't think a continuance is necessary. I'm going to oppose it. The city's witnesses are here.
Was your normal procedure followed for notifying defendant of discovery availability?
Your Honor, the original discovery was sent to Mr. Sotelo, and when he was appointed legal defender, back on August 15th, 2012. That I have. My candor to the court judge, I have no idea when we received these pictures. They were received by Mr. Sudi. I tried to contact him. He's not in town today. I haven't heard back from him. So I don't know. But they're not, I'm not planning on using them at trial today, so I don't think it, and they're not, I don't believe they're Brady material, so I don't think it's relevant, to be quite honest with you. The city's got two witnesses ready.
To preserve for the record.
Wait, one at a time. Based on them not being used at trial, Mr. Sotelo's request to be relieved indicating that under the statute that all material would be presented to his client. This is a matter that Mr. Sotelo represents would not affect his, Mr. Coughlin would not be affected by his withdrawal. possibility of jail sentence. It is simply a traffic violation. The city's not going to use them for the direct case. If Mr. Kaufman wishes to use them for issues of grading, that's up to him. But the motion to continue is denied. The trial will begin. Does the city have an opening statement?
No, Your Honor, all waive opening statement. The city does have 2 witnesses today.
Malcolm, do you have an opening statement?
Your Honor, I did have one last motion. I was hoping to make a motion for mistrial.
We haven't had a trial yet.
I believe I have to make it at some previous point there too to preserve it for appeal.
Do whatever you want, you can say that, but you can't do a mistrial when one has not occurred. You were never put in jeopardy before. It was continued at your defense, your attorney's request, whether that was proper or not between you and your attorney. But Mr. Sotelo asked for the continuance to brief the issue. This court granted. So the motion.
Then he didn't brief it. I was put in jeopardy when I was in jail for 20 days and I sustained a $40,000 attorney's fee award.
You weren't put, when were you put in jail?
Incident to the unnoticed July 5th. I was arrested on July 3rd.
That was months before this case.
No, that
Months
was,
before this trial case.
that was this case.
Yes, I understand that. But your motion
The Reno Police Department told me that they would violate the law and arresting me for trespass, even where I had a valid lease at the time, and they subsequently decided to take the tact of arresting me for disturbing the peace instead.
motion was denied, and motion for mistrial was denied.
And they asked it bases, therefore.
Motion for mistrial is denied because there has not been a trial. I'd like to see who name their first witness, and anyone else who will testify in the matter, please wait in the hall.
City calls Sergeant Dye to the stand.
Person die.
In the matters pending before this court, you swear to tell the truth, the whole truth, and nothing but the truth. I do. Thank you, sir.
Good afternoon, sir. Thank you for being here.
Good afternoon. Can you please state your full name and spell your last name for the record?
Brian Dye, D-Y-E.
What is your occupation?
I work for the city of Reno as a police sergeant.
How long have you been with the Reno Police Department?
Approximately 9.5 years.
Sergeant Dye, can you briefly describe your training and experience for the court with regard to traffic violation enforcement of the traffic laws?
In 2005, I believe, I transferred to the traffic division as a motor officer. And I held that position until January of 2009.
Have you initiated traffic stops as part of your duty assignment throughout your 9.5 years?
Several thousand.
I'm going to draw your attention to July 3rd of this year, around 10:41 a.m. Were you working that morning?
I was.
What was your duty assignment that morning?
I was assigned as a community action officer.
What does that mean?
It's a grant-based position that deals with repeat problems and problem solving.
Okay. And were you, as part of that duty assignment, were you in the station? Were you out in a patrol vehicle?
I was in my patrol truck.
And around that 10:41 a.m. on July 3rd, did you respond to the area of Summit Ridge and McCarran Boulevard?
I did.
And is that within the city limits of Reno?
I'm sorry, I might be too late, Your Honor, but I would just object on a relevancy basis to the testimony with respect to the grant-based position.
There's some objections overruled. It goes to its credibility as far as what he was doing. Go ahead.
Sorry, could you repeat the question?
I'm trying to remember what it was. Give me 1 second. Okay, Summit Ridge and McCarran Boulevard. Was your attention drawn to a silver Honda Accord that morning?
It was.
Okay. Was that vehicle mobile or stationary, the Honda Accord?
It was traveling eastbound.
On what street?
I believe it's Summer Ridge.
And where were you?
I was coming up the off-ramp from McCarran, from southbound McCarran, and then it kind of comes around by the old Kmart. There's a Home Depot up there.
Okay, were you also on Summit Ridge?
I was at the off-ramp, but yes.
Okay. And what drew your attention to that silver Honda Accord?
I observed a plastic Rubbermaid style storage tub fall off the back of it, and then a small gray SUV, I can't remember the make, but I believe the Suzuki, had to brake and then swerve around that tub.
Was the small gray Suzuki behind the Honda Accord?
Correct.
And where were you in relation to the Honda Accord and the Suzuki?
I was stopped at the turn portion to enter onto Summer Ridge.
So were you facing the same direction as them? Can you give us a little bit more of
It's
your
traveling
direction?
east, I'm facing northeast.
How far were you approximately from the silver Honda Accord when you saw the storage tub fall off?
Maybe 40 to 50 feet.
Did you have a clear and unobstructed view of that storage tub when it
I
fell
did.
off?
Yes,
And is that within the city limits of Reno?
it is.
That's court to no jurisdiction for the record.
So moved.
Did you initiate a traffic stop on that silver Honda Accord?
Well, the Honda Accord pulled over after, and then we activated our lights and pulled up behind it.
Okay, was somebody else with you?
So Officer Weaver was in the passenger seat of my patrol truck.
So you were driving?
I was driving, yes.
And the silver Honda Accord pulled over, you said. Did you make contact with the driver of that vehicle?
Officer Weaver made initial contact.
Did
I
you-
spoke with
I'm sorry,
the
go ahead.
driver later.
So you did eventually make contact with the driver of the vehicle?
Yes,
And were you able to identify that person who was driving that vehicle?
yes,
Is that person in court today?
yes. It's Mr. Coughlin.
Ask the court to know identification of the defendant for the record.
So noted, subject to cross-examination.
When the storage tub fell off of the back of the Honda Accord, were you able to see if it was tied down, secured down at all?
I couldn't. There was a mountain bike on a rack off the back of either the trunk lid or the bumper, and the storage bin was placed on top of the trunk lid between the rear window and the bicycle.
So the trunk wasn't open.
No,
And do you know approximately how fast the vehicle was going when the tub fell off?
maybe 20 miles an hour.
And did the tub land in the travel lane?
I'm sorry if I may just interject quickly, Your Honor. It might be too late, but I'd like to move just,
Objection for.
I don't know if it's an objection, just move to suppress any testimony or evidence related to the tub in light of an unlawful search and seizure under the Fourth Amendment.
Respond.
Your Honor, the officer testified it was sitting on the back of the vehicle, not in the vehicle, not in the trunk of the vehicle. Perched on the back of the trunk, it's in plain view. There's no search.
Objections of the rules. Fair review.
When the storage tub fell off of the back of the Honda, did it land in the travel lane?
It did.
I'm sorry, did it?
It did.
Thank you.
And you said the car directly behind it swerved?
First it applied the brakes, and then it drove around.
So there was no accident?
Correct.
And were there any other vehicles between you and the silver Honda Accord besides that vehicle that braked and swerved?
No, that was the only vehicle.
Was the defendant the only person in the silver Honda Accord when you made contact?
Yes.
Did you see anybody enter or exit the vehicle between the time the tub fell off and you made contact with the defendant?
No.
Was the defendant in the driver's seat of the vehicle?
Yes,
And you said the vehicle was driving approximately 20 miles an hour?
give or take 5.
It was moving, it wasn't parked on the side of the road?
Correct.
I have nothing further at this time, Your Honor.
Well, we have any questions for Sergeant Dye?
Yes, sir, Your Honor. Sergeant Dye, had you had any previous contact with the suspect prior to that July 3rd date?
Personally, no.
Did you testify at the bail hearing on July 5th as to some prior contact justifying your appearing there unnoticed to him to move to have bail increased to 10 times what it was?
Your Honor, I'm going to object as to relevance. Anything that happens subsequent is irrelevant to whether or not the defendant in fact
Yes.
committed this crime.
I will,
And is it possible to ask the defendant to not refer to himself in the third person? I find it confusing. So that we're all clear on who he's talking about.
it's easier if you talk about yourself, sir, but I'm not going to make a deal about that. You will need to wait, however, until the city is completed its question before you object to it or respond to it. As far as the relevancy of this material, what is the relevancy of Sergeant Dye's appearance after the fact in this case?
Well, I think it goes to witness bias and motive with respect to the extent to which his testimony here today may largely be motivated by an intent to mitigate civil liability incident to the wrongful incarceration of the defendant for approximately 20 days.
I will withhold ruling, but you're gonna have to tie this officer's subsequent testimony or behavior to bias. Otherwise, I'll strike it. So it's up to you.
So I'm somewhat unclear, Your Honor. Does that mean I can have him answer the question?
Bias and prejudice of a witness is always relevant. However, you're going to have to show that his behavior after the fact demonstrates that he was biased and prejudiced towards you.
Oh, yes, sir, Your Honor. So should I go off for proof?
So the question is, I have not granted, I'm not overruling nor affirming the city's motion at this point, or the city's objection, but I'm putting you on notice that you have to tie this up and not just go on a fishing trip as to what about this information as far as bias and prejudice. So you can go ahead and answer the question.
Okay, will you please answer? Sir,
Could you repeat the question, please?
Yes. And ask her, and ask simple questions, sir, not ones that ramble. And
Yes.
your information, what you're saying, as you know, is not evidence. So only ask questions of the officer that the officer can handle.
Yes, sir.
Perhaps I should have, and at this point I am going to stop for just a second. I do have noticed that you are, or have been, you are an attorney, you have been licensed to practice in the state of Nevada. Therefore, I did not go through the usual explanation of direct and cross-examination with you. That is perhaps a mistake I should have made. I shouldn't have assumed. At this point in the trial, I do want you to understand that the right to cross-examination is not a time for you to present your side of the case, nor disagree with the witness. What it is the time to do is perhaps get additional information from the witness, or clarify what they testified about. Once the city has completed its case, you will have the same opportunity to present a case, call witnesses, provide photographs or diagrams or whatever evidence that you feel is appropriate. Once both sides have rested their cases, both sides will have a chance to argue the cases. The city will go first and explain why they believe that the evidence presented here in court today shows that you're guilty of the offense beyond a reasonable doubt. the same opportunity to comment on the evidence presented here in court only. Nothing else, just what's presented here in court, as to why that does not show that you're guilty, at least not beyond a reasonable doubt. Because the city attorney does have the burden of proof, they'll have a closing argument if they wish to take it. Other than what I read to you as far as the complaint, I know nothing whatsoever about the case. I am somewhat familiar with the intersection simply because I drive in this town. But other than that, I know nothing about the case. Everything I need to hear must be presented either by the city's witnesses or by yours. And do you have any questions on procedures? Trial procedures. Do you have any questions about trial procedures?
Yes.
So I apologize that I didn't do that up for them. So at this point in cross-examination, any questions are directed to the officer, the officer, or the sergeant.
Yes. Sergeant, what was your basis for appearing on July 5th and testifying in support of a bail increase?
What was my basis for that?
Yes. Why did you do it?
Your Honor, can I just make a record of an ongoing objection? I don't want to stand up every time you ask a question, but I would like to make the record. Grounds of relevancy.
All right, so ongoing objection. You go ahead and answer the question.
We were trying to get your bail increased to keep you in jail long enough for us to not have to deal with you for a little while and give the city some reprieve.
Reprieve from what?
From going out on calls for service related to you.
Can you describe that more thoroughly?
You had numerous calls of trespassing, occupying a storage unit, and then harassment of the staff at 1680 Sky Mountain Drive.
Was it your understanding that I had multiple rentals and leases at that location?
3 storage units, if I recall correctly.
So your allegation of trespassing, how would that relate to one having?
Your Honor, I'm going to object. That's
Sustain that word.
Yeah, I asked what the objection was.
Relevancy is to the trespassing charge.
Well, he testified to it, so I think I have the opportunity to rebut it if prejudicial to the extent he's able to.
Mr. Conway, he answered your question. I would not have allowed the city to ask the question because it involves admissible testimony, but since you asked it, you got the answer.
Well,
So that's as far as it goes. And at this point, you're not showing anything that indicates that that Sergeant Dye even knew who you were when he saw this alleged occurrence with the Honda.
well, he
So
knew
be
enough to
careful.
testify in July.
You asked him a question. If he answers your question, you can't object. The city could not have asked him about other prior charges or prior bad acts, but since you asked them and he answered them, you're stuck with it. But at this
Well, I can
point,
clarify him, I believe. Your Honor.
there's no point in clarifying it because it's irrelevant to this issue unless you can show that Sergeant Dye made this story up here with this issue, with this traffic violation because of advanced information.
I think he just testified to it. He had an animus to remove me from the streets to, quote, help the public
That was
based upon
afterwards.
previous incidents
That was afterwards.
after this traffic violation. Well, he wasn't trying to protect the public based upon this traffic violation. He testified to incidents at Northman's apartments.
I gave you some freedom to try to develop prejudice from the officer. I don't find any yet. The issue that he testified or he appeared at a bail hearing was after the events of July 3rd and are not relevant at this point. So I would now rule on the city's motion on relevancy of Sergeant's appearance at a bail hearing as irrelevant to this case, and sustain their objection.
Your Honor, may I make an offer of proof?
Not if it involves anything to do with the sergeant's appearance at a bail hearing subsequent to this.
Well, may I preserve for the record?
Well, you've got to. I mean, obviously, you're going to have a record, but I do not want you to add any more material that is negative towards you, such as prior bad acts, which, as I said, the city could not get in. I will not consider them when it comes to the decision on this case. The decision on this case here today will be based solely on the facts of what occurred that day, not what occurred subsequent or before. And so at this point, I will rule that anything having to do the sergeant may have done after this does not establish bias or prejudice by a witness and is irrelevant.
Your Honor, may I preserve the Soldalby Cook County witness bias theory for the record?
Of course it's on the record, and you can argue whatever you want when you appeal it. But if you appeal it, you don't. But I'm not going to have you put any more on the record about this, about biases and anything else at this point.
Okay, and I'm just a little unclear how that impacts my ability to ask him questions about, for instance, what he was doing in the neighborhood that day, what brought him there, and what his specialty of.
Sir, I cannot advise you on how to try a case.
I know, but in terms of a contempt ruling, to be found in contempt,
I have not found you contempt. I don't intend to. I sincerely hope that does not come. So far, we've disagreed on issues, but you have done nothing contemptuous. I assume you will continue to behave that way, as would any person who's in court. So at this point, I'll ask you to continue as to anything that you wish to cross-examine as far as testimony that the sergeant is made on the record.
Yes, sir, and I'll just indicate that I'm terribly afraid being in this court right now. I've been found in contempt
Please do not go
twice.
any further with what you're afraid of that involves other parts of this court. You and I have not had an issue. I sincerely hope we will not have an issue.
Yes, sir. Officer Dye, what were you doing in the neighborhood that day?
We were headed to 1680 Sky Mountain Drive
For what purpose?
to meet with Mylan Krebs.
About what?
He had said you were harassing him that day, but I know that's hearsay.
What did he say I had done?
Your Honor, I'm going to object because that is hearsay and it's irrelevant.
It is irrelevant. Well, put it this way. It is hearsay, of course, but you're asking for the hearsay, Mr. Conlon. I do not want hearsay in this trial because I don't need it. This is a specific situation that occurred. Unless, well, I don't know if this individual that you just mentioned is going to testify. As far as I know, they aren't. I didn't see anyone else in the courtroom besides sergeant and an officer. But he was responding to a call for service. Beyond that, nothing else is relevant.
Yes, sir, Your Honor. If I may just preserve for the record that you said.
You have preserved for the record. You don't need to make that
It's
statement.
not on this, Your Honor. It's not on that. It's on the extent to which Mr. Krebs meant for our protection.
Do not go there. This is not a hearing about Mr. Krebs, whoever he is. You do not need to state, in the old days, there was an objection, sustained, and the other party had to say, preserved for appeal, or something to that effect. That's long since gone by way of the board. You do not have to inform the court that you intend to use that on appeal. You simply will have the record. So if you disagree with my ruling on a matter of testimony, you will have that on the record. You do not have to make a statement that you will be preserving it for appeal.
And that would include not having to provide the bases for.
What's it?
Well, I was always under the understanding I had to indicate the bases for asking. hearsay exception, the basis for why I was asking something, or an offer of quick relevance in order, on the record, in order to preserve for appeal any later argument that I might make
You
related.
preserve it for appeal. What I'm referring to is, there used to be a requirement that the party against whom the ruling is would have to say, it was before I even took the bench 25 years ago, but objection, overruled or sustained, and then there was a statement, I can't remember, but it's an antique statement that you would have to say that to preserve it. You do not have to do that because it's not necessary. You'll have the entire transcript, and anything having to do with credibility of witness is always an issue, so there's no need for you to preserve something for appeal. You've gotten my ruling, you can proceed from that if you wish.
Yes, sir, Your Honor, I'm having a little difficulty remembering where we left off.
You were asking me about the call for service at 1680 Sky.
Thank you. Okay. So you were in the area with respect to something that concerned me or involved me in some manner?
We were driving to the 1680 Sky Mountain Drive to meet with the manager and a maintenance employee, and we happened to cross you intro.
Were you aware when you were driving there that you were meeting with the manager and maintenance employee with respect to something involving me?
Yes.
Can you explain that?
No. The only part that's relevant as to why Sergeant was in the neighborhood, he was in the neighborhood responding to a call. Apparently the call didn't involve you, but as far as what the call was is irrelevant. Because what you're charged with is a traffic violation that occurred separate and apart from whatever Sergeant was called to. So please do not go any further with that. This is your opportunity to cross-examine on the facts of this traffic violation.
Yes, sir, Your Honor. If I may just say.
No. I ruled. That's it.
I was going to ask you something completely unrelated to that.
All right. Go ahead. I'm sorry.
Just to the extent that it's my understanding, sir, that while I don't intend to bring any civil action here, the city and Reno Police Department have a vested interest in getting some sort of conviction on something, even a minor traffic infraction here, in furtherance of mitigating any 1983 liability they may face. To the extent that, for instance, for the disturbing the peace charge, which I believe they would assert as the basis for effecting a custodial arrest.
Mr. Coughlin, you're asking for a legal opinion from a police sergeant who, while he's a well-trained police sergeant, is not an attorney for the city of Reno and is not in a position to be able to speak for the legal issues involving the city. Once more, you will have this is your opportunity to cross-examine Sergeant Dye on his testimony, which involved the occurrence at that location of Summit Ridge and McCarran.
Yes, sir.
That is all.
Yes, sir, and I'm not asking him for a legal opinion, sir. I'm stating the basis I think we're at.
Then don't go any further. But don't go any further. You cannot ask him for a legal opinion, which he cannot give you a legal opinion. So don't go any further.
Okay. Sergeant Dye, would you say you had a motive to effect an arrest that day?
No.
Did you testify earlier that you were trying to get me put into custody at the bail hearing because you wanted to help the people of Reno?
Objection misstates testimony, Your Honor. That was a question as to why her request for a bail increase, not a reason behind the arrest itself.
They're not substantially different. They both go to incarceration for extended periods.
Objection is sustained. The officer answered the question. Did he have a reason to place you in custody that day?
Motive.
And his answer was no.
Okay. Sergeant died. When did the motive to extend my stay in custody that you testified to earlier arise?
We've already covered that. It occurred after this. That is not a matter for this court. This is a matter of what the officer testified to occurred at that location. And I'm going to restrict it now. I gave you a great deal of latitude, and I'm not going to give you any more.
Yes.
This is a traffic trial. Please stick to the issues of the traffic trial.
And, sir, just because I don't want to continue lines of inquiry after you've told me not to, is it the case that any sort of questioning related to witness bias or motive should not be pursued?
You've made your point that that the officer, that Sergeant Dye appeared at a bail hearing and asked for a bail increase for various reasons. That point has been made. What that has to do with what he saw before that occurred is not relevant.
Yes, sir. Had you ever had any contact with or knowledge of the suspect prior to the July 3rd arrest?
Knowledge, yes. Contact, no.
And what was the knowledge?
That you had been the cause for multiple calls for service since the beginning of the year.
Were some of those calls made by the suspect reporting, say, a battery by the apartment?
Okay, again, I'm going to stop you. You're getting way out here on all these things that happened at the beginning of the year. For what it's worth, I am trying to get through a trial on a traffic violation. And I'm going to stay with that. And so what the officer, the sergeant may have heard about what had happened since the beginning of the year is done. I'm not going to consider it when it comes to this issue. I'm going to consider strictly the evidence presented about the events that occurred about 10:41 a.m. or whatever it was on July 3rd. So that's where I'm going to restrict the testimony to. That's my ruling. So no, don't go back any further.
Okay, and so to the extent to which his testimony may be colored by witness bias or motive is not grounds, it's not an appropriate subject for questioning.
You have established that he appeared subsequent to this to ask for a bail increase for whatever reason. For what that's worth, that will be part of the testimony. But as far as what he's heard over the previous 7 months, I'm not going to open that up.
Yes,
Way
sir.
beyond the scope of this case.
Yeah, more narrowly tailored
No,
to
we're
it.
done with that now. You've established that the sergeant did appear and did either personally ask or support a bail increase.
Okay. Excluding what you became aware of after this arrest,
I'm going to object. That's vague, Your Honor, and irrelevant. Mostly vague.
Let me answer the question.
excluding any motive or bias or what you may have heard subsequent to this July 3rd arrest, what were you aware of and or motivated by at the time of that July 3rd arrest to issue a citation or effect an arrest of the defendant?
I'm sorry, that was a very confusing question. Can you rephrase?
At the time of the July 3rd arrest, were you aware of anything arrest or cite the defendant?
At the time of the traffic violation, is that what you're saying?
Yes.
Or after that? I didn't even know it was you prior, so I don't know how I could have any sort of an errant motive. I didn't recognize your car. I'd never seen you in person before, so no, I didn't have any motive or
Okay.
anything when I
So is it
saw you.
prior to the vehicle, the Honda, the silver Honda being pulled over, you had no awareness that the driver there had any connection to the reason you were in the area? Is that correct?
That's correct.
Did your partner make any statements indicating that he was aware?
He knew.
Objection.
Hearsay?
It's hearsay, it's irrelevant.
Staying on hearsay again.
I think it would go to a party opponent admission, Your Honor, and
This criminal action does not apply. This is a hearsay statement outside of court, and I sustain the objection to hearsay.
okay, and just, I don't know if. I
The
can
other
say
officer
process
is not a
the
party
question.
to this case. The only party to this case besides yourself is the city of Ormaas.
Okay, and as far as I'm excited on around sort of present sense impression, hearsay exception.
It is hearsay, there's no exception.
Yes, sir. When did you become aware that the driver of the vehicle was connected to your reason for being in the area?
After the car had already stopped by the curb line, and after we had already stopped, or since I was driving, since I stopped my truck behind the Honda.
And how did you become aware?
The other officer is here today, and I'm sure you can ask him that. So we don't
Well,
have any
I'm
more
asking you
hearsay.
that. I'm asking you how you became aware.
My partner told me that that was your car after both vehicles had stopped.
Prior to the driver of the Honda exiting the car?
Prior to contact.
Prior to any kind, he just knew straight out from sight, he recognized it as the suspect's car?
The car, yes.
Did he make any statements at that time about
I
the car?
think you can ask him after I'm done.
Your Honor, that's already been ruled on.
Objection is there an objection?
Yes, Your Honor, it's the objection you already sustained.
And it's
I
not going,
sustain that objection already.
it's not going to prove the truth of the matter, sir, but the effect on the listener.
You'll have to show that.
Show what effect it would have, sir.
Yeah.
I think it would go to the question of why the officers proceeded in the way they did. And it may go to the decision to arrest and or issue a citation.
I will sustain the objection because neither one of those is relevant. The sergeant indicated that he saw you, he saw the tub fall off the car, he saw what he believed to be a traffic violation, he pulled in behind you, he did not know who you were. So at that point, he had already seen what the alleged violation was.
Yes, sir.
And so anything as far as discussion between his partner and himself is irrelevant.
Yes, sir.
It is not irrelevant, it's a hearsay, and I can see no objection to hearsay that it would fall under. It doesn't matter what somebody's perception is at this point in the game.
Okay.
As far as what happened, whether you were arrested or cited, I don't know. I don't have that answer. I just know that you were charged with an offense. That's it.
Okay. So Sergeant Dyke, is it correct that you testified earlier, you said, were you driving?
I was driving.
Okay. And where were you at the point at which you were able to discern, discern the tubs allegedly falling off the silver Honda?
It's hard to describe, but there's a kind of a sweeping right to merge onto eastbound Summit Ridge, and I was in the turn.
You were in the turn, you weren't stopped at the corner. Is there a stop sign there?
I'm not sure if it's a stop or a yield sign for the turn. I know if you continue north, there's a stop sign, but I'm not sure if it's a yield or a stop if you turn right. But I was-
Okay. And you testified that there was a vehicle, at least one vehicle between you and the silver Honda.
Correct.
Did that vehicle obscure your vantage point?
I'm looking north by northeast, 2 cars come east. So one passed, which was the Honda, then followed by a gray SUV. So no, not obstructed.
Well, I mean, did you personally eyewitness the tubs at the moment they allegedly fell off the Honda?
Yes.
Was that view obscured in any way by the at least one vehicle between you and the Honda?
No,
Do you recall whether you were stopped at that time?
I don't. I might have been either stopped or going very slowly.
So why would you say your eyes were trained on a Honda 2 car lengths ahead of you rather than the road in front of you?
I used my peripheral vision.
Why?
I have to pay attention to all my surroundings, not just what's immediately in front of me.
So there was nothing particular about the Honda that caused you to exert more focus,
Just that a tub fell off the back.
but prior to this alleged event occurring?
No, it was a vehicle I had to slow for because it had the right of way.
Okay. And you said you couldn't see whether or not the tubs that you testified to were tied down or not, or secured on the vehicle?
I couldn't see any ropes, bungee cords, chains, cables, anything like that.
Well, it seems though earlier did you say you couldn't see whether or not there was any ropes?
Correct.
So in fact, would be true to say there may have been, but you just weren't positioned so that you would be able to so discern such items?
I didn't observe anything. Whether or not something was there, I couldn't tell you. I couldn't see if anything was there to tether the tubs.
Did you make any subsequent investigation or efforts to determine whether there was, or ask any questions related thereto?
Once the Honda was already stopped, I didn't see anything that would indicate it was previously tied.
Okay, did you make any subsequent investigation or ask any
I
questions?
looked at the car, and I didn't see anything obvious or overt.
Did you look around the area where the tubs allegedly fell off?
No.
Why not?
Why didn't I walk back into traffic? Because the tub had already been moved by a construction worker. So I didn't even know where exactly it was after the stop had already been made.
Where did you pull the vehicle over? Or you testified earlier that the vehicle pulled over itself?
Correct.
Prior to your putting on your lights?
Yes.
So just to be clear, your testimony is that the vehicle pulled over on its own accord, as far as you know, prior to your putting your lights on.
Yes.
Why did you put your lights on if the vehicle had already pulled over?
As it was a construction zone, I didn't want to be hit by another vehicle traveling in the same area. Also, to initiate a stop. I know it sounds contradictory in nature because there's already a stop, but to indicate that the police were behind you and would like to speak to you,
Okay.
as well as a safety hazard from the rear.
Okay, did you subsequently search that vehicle?
A search? No, we performed a vehicle inventory because it was towed.
How is that different from the search?
Your Honor, I'm going to object unless there's some relevance to the traffic violation that the officer witnessed.
Sustained objection.
Your Honor, may I offer proof? Or I don't even know if I'm using the term correctly.
I sustain the objection because nothing that's been testified to would have been inside the vehicle. The officer testified that it was a search pending because the vehicle was being towed, and that's a matter of inventory search. There's nothing to do with this. Nothing from the inventory search has been testified to in this case. So my objection is sustained.
I understand, sir, but I believe I need to preserve
It's preserved for appeal. Go ahead.
the wrongful Fourth Amendment search.
There was no Fourth Amendment search, sir, since what was seen was laid outside of the vehicle. And there's no right to privacy on something that falls off a vehicle.
Well, he testified to going through the interior contents of the car.
That's a different matter. That would be only a problem if there was something found in the search that's being used against you. And nothing involving this case was found inside the vehicle. There is an exception for inventory search so that your safety, the safety of your property is maintained. But I'm not going to get into a long discussion on constitutional law on search and seizure. My ruling stays.
Yes, sir. Did you cite the individual or subject them to a custodial arrest?
Custodial arrest.
And why was that?
That was based on the disturbing the peace, the unsecured load, as well as an insurance violation, and the belief that had you not been custodially arrested, you would have returned to the property at 1680 Sky Mountain and caused more problems. The behavior would continue in the disturbing the peace.
Was it your understanding the suspect still had a valid lease at that property and therefore claimed the right to go there lawfully?
To be on property?
Yes.
Yes.
So you're not taking the position that the suspect was doing something unlawful by going to the property?
Not by
I'm
going
gonna
to the property.
object. This is far beyond the scope of direct examination. It's irrelevant.
Objection is sustained.
Yes, sir.
We're not going to try some other case.
Yes.
Say to what occurred as far as the traffic violation.
Was it the case that pulling the suspect over for an allegation of a minor traffic violation enabled you to effect a custodial arrest for something outside, allegedly occurring outside your presence?
Objection, Your Honor. The officer's state of mind is irrelevant and testified that he witnessed a traffic violation. He has every right to initiate a traffic stop.
He's already testified this was stop has already occurred, so sustain the objection.
Did the suspect show you any proof of insurance at that time?
I believe he tried to show my partner something on your iPhone.
What was that?
Your Honor, I'm going to object. He's not being charged with that currently. It's irrelevant as to the traffic violation that stands today. And Officer Dye testified that it was something that was shown to a different officer. He has no personal knowledge of what was on that iPhone, though.
Objection sustained.
You testified earlier as to your experience and training with respect to traffic stops and the thousands of stops you've effected throughout your 9-year career. Is it your understanding that the particular section of the municipal code cited attaches only to trucks?
We moved it to NRS. I'm not familiar with the chapter in which the NRS is in.
Well, what's your understanding of what the charge was that we're trying here today?
Unsecured load.
And is it your understanding that that's a NRS section or a municipal code section?
Your Honor, I'm going to object. It's calling for a legal conclusion. It's if the defendant wants to argue that during closing argument or even during his testimony, if he chooses to do so under oath, that he was cited with the wrong code or charged with the wrong code, that's fine. But the officer has no standing to testify as to a legal allegation which has been amended and what stands today. This is a fishing expedition.
The original citation, the language of the citation is the same as the citation today. However, it was cited originally under RMC section. So he's asked to amend it to a different RMC section, but as to whether or not legally the section applies only to trucks or to cars, that is a legal opinion that the officer is not in a position to make.
Yes, sir, Your Honor, and I'm not aware of any motion to amend the charge. If that's something that would, is that
Amended, the
today?
complaint was filed, and the language was identical. The only thing that was changed was the code number, and it was the same notice of the charge. So at this point, I allowed it, amended complaint to be filed.
Today?
I'm not sure when it was filed. It was amended
It was filed on October 11th, Your Honor,
October 11th.
and it was sent to the defendant's last known address. I have a certificate
I
of
don't
service.
believe I ever got anything of that sort.
That's your last known address issue. We've already covered that.
What address would that be?
A P.O. box.
October 11th. What PO box? Could I see the document? This just refers to a foregoing document. And was this a first class postage prepaid? Yeah, no, I don't recognize this. I don't believe I ever received this document.
We've already covered that pre-trial motions. You did not notify the court of the change of address until after. And this is a matter we've covered pre-trial. It has no relevance here today as far as this witness. If you have any questions for cross-examination of this witness, fine. If not, we're done with it. I'm not going to stay here all night on this case. I'm sorry. You can blabble. You can keep on talking, but we made your record. You don't even know what decision is going to be made. But unless you have another question about the facts of the case, then I think we're done with this witness, because he is not in a position to testify as to the statutes, as to the law, as to what the legal opinions are, or anything else, whether or not there's some other massive conspiracy against you. He saw a car that he did not recognize, and he saw what he believed to be a traffic violation from that car. And that's what he testified to.
Sergeant John, it was a car and not a truck that you saw?
Yes, a Honda Accord, I believe, is a car.
Did you or your partner cite the suspect for a failure to secure a load violation on a truck?
Your Honor, I'm going to object. It's irrelevant. We're here about what he's currently charged with, which is NRS 484D.850 subsection 2.
I have what we originally cited, and
When
that
you
is
say-
part of the record. The original citation was under a different number, and that was the whole point of the continuance last time, and nothing occurred with that.
When the
Do
city
you have any more questions for Sergeant Dye about what happened on July 3rd at 10:41 a.m.?
Yes, sir, Your Honor. I'm just trying to clarify that when the city says they didn't get something from me, it seems to be taken as true. But when I say I didn't get that from them,
You already testified you didn't go looking for it, and it was sent to the wrong address because you hadn't notified us of the correct address. Now, whether the post office did or didn't forward it to you, I don't know.
You're referring to the court's own notice of the hearing, not the city attorney's motion to amend the complaint, which goes to the specificity and requirement that they plead and present.
Those are all issues you can handle depending upon how this case comes out. But the fact that you didn't receive it, because as you already said, you changed your address.
I filed the official USPS change of address.
But that's not, the sender cannot know that.
I believe I notified the city attorney of my new address.
But you didn't, okay, we're changing. Stay with this witness Excuse me. End of story.
Yes, sir.
You've cross-examined him as far as you're gonna go.
Yes, sir.
Do you have any other questions about what happened on July 3rd at approximately 10:40 a.m.? About what this witness claims to have seen?
Yes, sir.
Hearing no questions, witness is excused. Sitting further witnesses.
The city calls Officer Weaver to the stand. I have no idea.
A note for the record, Officer Weaver just handed city attorney
He didn't hit, he put something on
Ormaas
the
a
table.
stack of papers.
Look, stop, wait a minute, folks. Everybody freeze. Sit down. I've got this stuff. All right, swear the witness.
Raise your right hand. In the matters pending before this court, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sworn.
Yes, ma'am.
Your Honor, may I interject for the
You will
record?
have a chance in just a moment. Wait a minute till I know what this is. Please have a seat.
Good evening. Can you please state your full name for the record and spell your last name?
It's Alan Weaver, W-E-A-V-E-R.
What is your occupation?
I'm a
There's an
police.
objection to this witness testifying. Is that what you?
Well, Your Honor, would this just place that stack of papers upon entering the courtroom down on the table in front of
And that's a problem because?
I don't know. I've never seen it done before. City Attorney Ormaas seems somewhat furtive about it, so I just thought, my objection for the record. It seems like it might be.
It was in my way, Your Honor. I moved it to the other end of the table. I haven't looked at it.
So you're saying he didn't place it down?
He did, and I
Stop
moved
this.
it.
I haven't heard an objection.
Well, I believe that's improper.
There's nothing improper with a witness putting something on a table. I don't even know what the something is. Go ahead, Ms. Owens.
What is your occupation?
I'm a police officer,
With?
the city of Reno,
How long have you been a police officer with the city of Reno?
since 2004.
8 years. Can you briefly describe your training and experience with regard to enforcement of traffic violations or traffic laws?
Objection of relevancy.
I don't know the number of hours that I've received in training of traffic enforcement laws, but I received training in the academy related to the Reno Municipal Code and traffic rules and regulations.
Have you passed all of your training?
Yes, ma'am.
I want to draw your attention to July 3rd, 2012, around 10:41 a.m. Were you working?
Yes, ma'am.
And what was your duty assignment that morning?
I'm assigned to the community action team.
And during that assignment, were you in the police station? Were you out in a patrol vehicle? Where were you?
Well, we were in the police station early in the morning and then received a complaint from an apartment manager.
Objection of relevancy.
Overruled. Mr. Wise out there, so.
And began driving to the apartment complex.
And around that time, 10:41 a.m. on July 3rd, did you find yourself in the area of Summit Ridge and McCarran Boulevard?
Yes, ma'am.
Were you in a patrol vehicle?
Yes, ma'am.
Were you by yourself?
No, ma'am.
Who were you with?
At the time, Officer Dye.
Were you driving, or was Officer Dry driving?
Officer Dye was driving at the time.
Was your attention drawn to a silver Honda Accord in that area on that morning?
Yes, ma'am.
What drew your attention to that silver Honda Accord?
As the silver Honda Accord crossed the intersection at the four-way stop on Summit Ridge and drove on to the McCarran overpass, Rubbermaid style plastic storage tote, for lack of a better description, fell off of the trunk lid of the car and into the roadway.
Did it land in the travel portion of the roadway?
Yes, ma'am.
Did this happen within the city limits of Reno?
Yes, ma'am.
I'd ask the court to know jurisdiction for the record. Did you have a clear and unobstructed view of this storage bin falling off the Honda Accord?
Yes.
Was the storage bin in the vehicle or on the vehicle before it fell?
On the vehicle.
Did you make contact with the driver of the vehicle?
Yes, ma'am.
Is that person in court today?
Yes, ma'am.
Can you please describe, point out that person for the court? Okay, can you describe what he or she is wearing and where he or she is sitting?
He's wearing a suit, has glasses down toward the end of his nose, and he's seated to your left.
Ask the court.
Was
Was he the driver of that silver Honda Accord?
Yes, ma'am.
At any time when you were, during this incident, did you observe any ropes, cords, tethers, anything securing the load onto the back of that vehicle?
No, ma'am.
I have nothing further, Your Honor.
Yes, Your Honor. Officer Weaver, did you have a occasion on or about September 21st to threaten the suspect or defendant here with another unsecured load violation at Superior Minute Storage on West 4th Street in Reno, Nevada?
Your Honor, I'm going to object as to relevance.
It goes to on bias, misconduct, pattern, and practice.
Was the saying the objection is argumentative, terminology used. Beyond that, whether or not this officer is going to cite you again for the same violation, I don't see any relevance for that either. The relevance is what occurred on July 3rd. So I'll sustain the objection.
Where were you exactly, and where was the vehicle exactly at the point in which you alleged to have discerned, seen, personally eyewitnessing the tubs fall off the vehicle?
Can you repeat the question?
Sure. Let me break it down. Do you allege that you personally witnessed the tubs fall off the vehicle, the silver Accord?
Yes.
So, okay. You didn't infer that. You personally eyewitnessed it occur?
Yes.
Okay. So when that happened, where were you and where was the Accord in relation to any landmarks you can remember from that area at that time?
We were driving towards the, I guess we were traveling northbound toward the intersection in the right turn lane, preparing to go eastbound onto Summit Ridge, and the Honda Accord was traveling through the intersection, and we would have had to yield for the Honda as it passed through the intersection.
So, is it accurate? Okay, so when, I didn't hear anything about when it fell off and where it was and where you were when you personally eyewitnessed it.
The item fell off the cord, or the Honda, on the east side of the intersection.
So, prior to the Honda exiting the intersection, it fell off?
It was right at the edge of the intersection, yeah.
And where did the items, and was that intersection the four-way stop you referred to earlier?
Yes.
Okay. And where did the items wind up?
In the roadway.
Would that be in the middle of the intersection? Or?
I don't recall exactly where they landed as far as how far into the intersection or into the roadway, but they were in the traveled portion of the road.
In the intersection. Okay, and so was there any car between you and the Honda at the point at which you discerned these tubs? And the point at which they allegedly fell off?
I'm sorry, I don't understand.
Was there any vehicle between, I guess, obscuring your vantage point of these tubs falling off the Honda?
No.
Was there subsequently a vehicle between your patrol vehicle and the Honda?
Yes, there was another vehicle that passed through the intersection and had to brake and swerve to avoid striking the tubs that had fallen off the car.
From what part of the intersection did that vehicle?
I don't recall.
So do you not recall whether that vehicle was initially behind the suspect's car?
No.
Okay. So at that four-way stop, is it accurate to say the north of that stop would be entering into the Home Depot parking lot and or that 7-Eleven there? The south would be where your vehicle would have been located coming up north, headed north off McCarran. The west would be headed towards the Sky Mountain Drive address, and the east would be an apartment complex.
No.
How would you describe the 4 points of that 4-point stop?
The east would be towards the Sky Mountain address, and the west would be towards the apartment complex.
Yeah. And you're saying that the Honda originally was stopped at the westerly part of that 4-way stop?
I don't recall where the Honda came from when it entered the intersection. I just remember my attention was drawn to it when it was traveling out of the intersection eastbound and the item fell off the trunk.
Okay, I thought you said the item fell off in the intersection while it was traveling prior to it hitting the east boundary of the intersection.
It fell off on the eastern side of the intersection. You may have misunderstood.
Okay, and did you proceed directly after it at that point?
No, another car went through the intersection and then we proceeded.
Okay, and then was that car at the time that the items fell off the Honda? Was that car that subsequently proceeded through the intersection? Was it stopped? What was it doing at the time that tubs fell off the Honda?
I don't recall.
Would it be fair to say that car had to have been stopped at one of those 4 stop signs at that 4-point intersection? If the Honda, as you say, hadn't completely reached the eastern boundary of the intersection when the tubs fell off?
The car could have been stopped at the intersection, yes.
You say that car that subsequently followed the Honda, it had to swerve as a result of those? Is that correct?
Correct.
Where did it swerve?
To avoid the tub that was in the roadway.
But I mean, at the point that it swerved, was it in the middle of the intersection?
It was on the eastern side of the intersection where the tub was located in the roadway.
When that vehicle, I think was it a Suzuki, I think? Might have been characterized as?
I don't recall what kind of car it was. It was a sport utility vehicle, a smaller one. I don't recall what type.
Okay. Did that vehicle hit the tubs?
No, sir.
So the tubs where did they come to rest?
roadway.
Okay. Would that have been in blocking your patrol vehicle?
No, there's a merge lane for traffic coming from McCarran onto Summit Ridge, and we were in the merge lane. We wouldn't have traveled through the intersection. There's a gore area between the northbound through lane and the
So the tubs would have been behind you by that point.
by the time we were onto Summit Ridge, the tubs would have been behind us. That's correct.
And did you pull the vehicle over, the silver Honda?
Yes.
Did you have to put on your lights to get it to pull over?
I don't recall if the vehicle pulled over before the lights were activated or not.
But didn't you just testify that you pulled the vehicle over?
The vehicle was stopped, that's correct.
No, but I'm saying you testified that you effected a pullover of the vehicle. You pulled the vehicle over. Is that not what you just testified to?
Your Honor, that misstates testimony. He just testified he doesn't know whether the lights went on before or after the vehicle pulled over.
Your Honor, that
Which I believe is a
made no mention
clarification of his prior
It's
testimony.
been answered several times.
She's openly coaching the witness objection.
Overruled.
She's coaching the witness with her objection.
Overruled. You asked the question several times, the officers answered each time.
He answered it contradictorily, and I was seeking clarification, and she proceeded to coach him with her objection.
Objection? Your objection is overruled.
Yes, sir.
Proceed.
So I'm confused now. Did you pull the vehicle over?
So I don't recall if the vehicle was stopped prior to the activation of the emergency lights, or if it stopped because the emergency lights were activated. But once the vehicle was stopped, I contacted the driver, yourself, in the driver's seat of the vehicle.
Okay. And what did you say at that time?
You provided a driver's license and identified yourself to me.
No, I said, what did you say to the driver at that time?
I explained why I pulled you over.
Did you make any menacing commentary or smug comments referencing any earlier interactions with the driver?
I don't believe so.
Okay. Had you previously threatened or attempted to break into the driver's rental at Sky Mountain Drive and threatened to get the hydraulic explosives to gain entry?
I'm going to object as to relevance.
Overruled.
No, sir.
Had you at any time attempted to force the door up at the driver's rental?
No, sir.
Had you witnessed the manager of the apartment complex do so?
No, sir.
Had you ever had interaction with the driver at that 1680 Sky Mountain address?
Yes.
Can you describe it?
Yeah. The community action team has 2 social workers from Nevada Mental Health that are assigned to the unit, and we responded there with the social workers in an attempt to provide you some assistance.
Had the driver sent you an email containing a video showing the apartment complex manager assaulting him on her about June 5th through 18th?
I'm going to object as to relevance.
At this point,
Not
I will
related.
sustain the objection. I'll let you get some ways, Mr. Coughlin, but we're getting far afield. This officer has testified with his contact with you, and that's it.
Well, he
I'm not
testified
going to
as a
allow
negative
testimony as to
contact.
what somebody else may have sent somebody about a video. So the objection to relevancy is sustained.
Okay. Had the driver of this vehicle previously contacted you in any manner?
I've had contact with the driver previously, yes.
Had he sent you anything written?
I sustained that objection already, Mr. Coughlin.
Oh, I thought you sustained it as to what somebody might have sent somebody, not me sending the officer in question.
All right. I'll be specific. I'm sorry if I wasn't. what may have been sent back and forth between you and the officer concerning something that has nothing to do with this case is irrelevant.
Okay, and if
It's irrelevant, don't go any further.
okay, so I can't preserve why I think it's relevant, or
It is on appeal. I mean, it is preserved for appeal. You can do whatever you want to with it. But right now, I'm telling you, it's not relevant to this stop.
and I'm just saying, my understanding is it's not
It
preserved.
is not relevant to
specifically.
this stop. Do not go any further, Mr. Coughlin.
Yes, sir. Did the driver show you his proof of insurance at the time of the stop?
He showed an email on his phone that was related to insurance.
Was it an email or was it a PDF of the proof of insurance card from his insurance carrier?
I don't know.
I'm not going to
Did you
object
view
any
it?
further questions along this line. He's not charged with insurance.
I'll rule the objection. It goes to the officer's memory of what occurred that time.
I don't know which type of file it was on the phone, or
Did you view it?
I did see text on the phone. I don't know which type of format that it was in.
Okay, but would you say there's a difference between an email and an exact copy of the insurance card presented on the screen of the phone with all the numbers for the driver's USAA insurance and otherwise an exact replica of what one might print out
You're
on it?
testifying now, sir.
No,
So don't testify.
clarifying.
No, you're not. You're testifying. The
Can you-
question was proof of insurance shown? The officer answered, yes, it was on a PDA or a cell phone. It's irrelevant at this point, beyond the fact that it shows that the officer remembers what occurred that day.
Well, Your Honor, I believe what his answer indicated more ambiguity. He said something about an email.
Well, it doesn't matter. The question was whether or not he asked you for insurance or you provided it. He answered by saying he provided insurance on some sort of electronic device. Beyond that, it's irrelevant. You're not charged with an insurance violation. It only goes to whether the officer remembers what occurred at the time of the
It goes to
citation.
motive and bias, and it mattered enough
No,
to
there's
keep
not
me in
the
jail for
motive
20
and
days
bias. Sir, we're done with that.
with this website. Oh, so
No, I'm saying we're done with any questions about whether it's a PDA or a fax. I don't care. You weren't charged with, you were, I believe, originally charged with not having proof of insurance. That was dismissed because you provided proof of insurance. That's over and done
after
with.
20 days in jail, it
Sir,
was dismissed finally after they
Sir?
raised the bail.
sir, that's not before us today. The only reason I allowed the officer to answer was to determine whether or not the officer remembered the stop. And usually when an officer makes a stop, they ask for license, registration, and insurance.
Yes, sir. Was this the sort of stop where you might issue a warning or citation rather than effect a custodial arrest, typically?
Objection, hypothetical.
That's what?
It's vague and would you generally do this sometimes? That's not a specific question and it's irrelevant as to whether or not this crime was committed. Your Honor, he's trying to get at things that may be appropriate in other courts, but not in this court for this trial on this criminal charge.
What the officer would normally do is irrelevant. It's only what's relevant is what he did do.
Officer Weaver, can you describe what the defendant did that was illegal that day?
He was driving a vehicle and there was an unsecured plastic coat on the back of the vehicle and it fell off the car into the roadway.
And is it your understanding that that is tantamount to an unsecured load violation?
Yes.
Did you write that citation or arrest report wherein that charge was included?
I wrote the declaration of probable cause.
To effect an arrest
Yes.
for the traffic citation?
Yes. There was also a disturbing the peace arrest that was made because the offense was likely to continue because of your continuous contacts with the staff at the Northwind Apartments.
And were those contacts incident to being there under a lawful lease?
Objection.
Sustained. That's not for this trial.
Yes, sir. May I move to strike his testimony then with respect to?
No, I won't consider it. You can't strike testimony that you asked for, but it's not relevant to this case,
Okay.
so it will not be considered.
Did you immediately write a citation, or did it take some time to decide what to do?
Are you asking me how long it took to?
Or decide whether to arrest and or write the citation? See, I'm sorry, to back up, you said the arrest was made for the traffic citation.
Arrest was made for disturbing the peace, and you were also charged with the traffic offense and not having a valid proof of insurance. I don't recall the exact amount of time that it took. If I was allowed to review the CAD printout of the call, I could detail for you the times.
Okay, did you consult with anybody in deciding to make the arrest and citation?
I believe I spoke to Sergeant Bradshaw and Lieutenant Weeking about the incident.
Are you aware of whether Lieutenant Brown had threatened to have the suspect arrested for criminal trespass in the days
Objection.
previous?
Sustained.
Okay. Why did you speak with Weeking or Bradshaw?
I spoke with him just to inform them of where I was and what we were doing.
Why? Do you always do that for traffic citations, or?
Only when it's somebody that's a frequent, somebody that we deal with frequently, that we have been tasked with providing assistance or doing something to prevent a drain on police services. We contact them.
Had you been told to contact them, or did you do that on your own accord?
No, I did it on my own.
Why did you choose Sergeant Weeking or Bradshaw to contact?
Why did I choose them?
Yes.
Sergeant Bradshaw is my sergeant, and Lieutenant Weeking was the patrol watch commander who happened to drive by the traffic stop.
Okay, are you aware of whether Sergeant Bradshaw ordered the suspect arrested for a custodial jaywalking arrest on January 12th?
Objection. Relevant, Your Honor.
Sustained.
Okay. What did Sergeant Bradshaw tell you?
Objection. Hearsay. Irrelevant.
Sustained.
The fact I'm a listener.
Sustained.
Okay.
The fact that you've had multiple contacts with law enforcement is not relevant in this case. As I said in the beginning, I'm only going to be considering what I testimony concerning this offense.
Yes, sir. Is it your understanding, sir, that if something falls off someone's vehicle, no matter how minor, it's sufficient basis for you to write a citation of the variety that you wrote here?
Yes.
Okay. So if someone had an empty aluminum can for a soda drink, like a Coca-Cola, on their in their pickup truck, and it fell off, that would be a sufficient basis for you to?
Objection. Relevance. Incomplete hypothetical, Your Honor. That's not what's before the court today. That's not what happened on that day, according to the testimony.
I'll sustain the objection.
Is it
Not
your,
relevant.
is it your understanding that the charge you cited the defendant with was related to securing a load on a truck?
Your Honor, this is the same objection. This is the same line of questioning the court already forbid during the testimony of another witness. It's not any more relevant now than it was then.
It is not relevant. It is what the officer issued the citation, what his legal, whether he believes it applies only to cars or to trucks or whatever, he wrote it under that citation.
Yes, sir.
So it is irrelevant. It was, I did rule on it before. Do not go there any further.
Yes, sir. I'll just try to wind it up here quickly, Your Honor. Did you move, or anybody move the vehicle prior to taking photographs of it?
Excuse me?
Did you take photographs, or anybody with the police department take photographs of the vehicle that day?
Your Honor, this is, I'm going to object. It's beyond the scope of direct examination.
Just for economy, it might help. Might not need to call them on direct, sir.
As to the question whether any photographs taken, objections overruled. You can answer that question, officer.
There were photographs taken of your vehicle, yes.
Who took them?
I believe Officer Dye took the photographs.
And were they taken where the vehicle was pulled over, or was the vehicle moved and then they were taken?
No, the vehicle was not moved.
So where was the vehicle when it came to rest? Incident to the, I guess, when it either was pulled over or when it pulled over, whether or not it was pulled over by the police, or did the vehicle come to rest?
On the overpass?
Okay, so it was on the overpass.
I believe so, yeah.
Okay. It wasn't more towards that kind of senior home after the overpass on the right-hand side there?
No.
Okay. But the vehicle was not moved. Did anyone with the police move the vehicle that day?
No.
It was just the tow company moving it?
Yes.
Okay. Did you see any sort of straps or anything on the vehicle or the bicycle position on the back of the vehicle that might have indicated any load thereon had been secured?
No.
Okay. I don't have any further questions, Your Honor.
Any further?
Just very briefly, Your Honor. Officer Weaver, at any point did the tub become loosed from the vehicle?
When it fell off.
Did it become detached from the vehicle?
When it fell off.
Did it become a hazard to other users of the road?
Yes, ma'am.
How?
It was approximately 3 foot wide by a foot and a half deep and probably 2 feet tall. It fell off into the roadway. If it had been full of anything of, I don't know, any kind of weight, it could have caused damage to a vehicle and potentially an accident.
Is it a hazard to the vehicle that had to brake and swerve around it?
Yes.
I have nothing further.
Can I ask one question?
Yes.
Was there anything in the tubs?
No.
So when you testified that if it had something, it would have been a hazard, does that imply that your assertion that there wasn't anything on them constitutes a lack of a hazard?
The hazard was that the item was large enough that drivers would have had to swerve to avoid colliding with it.
Okay, but when you testified as to if there had been something in it, what were you referring to?
I don't think that the tub would have actually done much physical damage. I mean, a vehicle could have driven over the tub and there would have been damage to the car, but there wouldn't have been injuries or anything along those lines. If the thing had been full of concrete, on the other hand, it was large enough that it could have potentially caused injury to anyone or to an individual in a vehicle.
Okay, and from what you saw, would you say it was apparent to anybody that the tubs were, who may have had to decide whether or not those tubs were something with something like concrete in them or not? Was it apparent that the tubs were empty or
No.
wouldn't present any? It wasn't apparent.
No.
So somebody wouldn't know that by how what they perceived when they allegedly fell off.
Correct.
And you based that upon your own witnessing the tubs fall off?
Yes.
And it wasn't apparent that there was nothing in the tubs when you witnessed them fall off?
No.
How could that be?
Lid.
So was there a lid on the tub when it fell off?
That's correct.
On both of the tubs?
They were stacked tandem with the lid.
So was it only the tub on top had a lid?
I don't recall if there was one or two lids.
Well, you just testified that you knew there was lids on them, and
No, I
therefore
said-
it was not apparent to others there whether or not there was concrete in the tubs.
I said there was a lid.
Was it on?
Yes.
Okay. Did you recover 2 lids that day?
I don't recall.
But you're sure when the tub fell off, it had a lid affixed to it,
Yes.
making it impossible to discern whether or not there was something sufficiently heavy in the tub to present a hazard.
It was still a hazard in the roadway. It just seems more
Objection
dangerous.
non-responsive.
It seems more dangerous if you're running into something that weighs 300 pounds as opposed to a plastic tub.
You're saying that the level of danger that would be perceived by you or someone there that day, it was not possible to determine due to the lid being located on the, nothing from how it behaved in falling off or hitting the ground or anything of that sort revealed whether or not there was something sufficiently heavy in it to present a hazard.
Objection asked and answered, Your Honor. He's already answered this question 3 times.
It's also mischaracterizing the answer.
Okay.
It also testified it was a hazard, regardless of whether anything was in it. It would have been a more serious hazard had there been 300 pounds of concrete, he said. But the issue is the tub itself, even empty, would be a hazard. Because if it falls off in front of your car, and your car isn't a jacked up pickup truck, you're going to hit it. And you probably don't want to hit it, which means you probably swerve, and that's the hazard.
Yes, sir. I have nothing further, Your Honor.
Thank you, Officer. You're excused.
Thank you, sir.
Is there any further?
Your Honor, the city rests. And if there's going to be a defense case, I'd ask just for a brief recess.
Let's take about a 5-minute recess or so, and then Mr. Kaufman, will be your opportunity.
Yes, sir.
Yep. Right now, for restroom use or whatever. Yeah, and then it's cross, and then he's gotta either testify or do whatever. So, yeah. Yep. All right. Bye. I was ordering pizza.
Whatever hours you're working, let me know what they are.
All right.
I'll approve it.
You don't have summer party?
Hmm.